Hello and welcome back to another episode of the Injury Law Pod. I am your host, Eric Bartlett, 28-year personal injury lawyer. And this is the podcast where we talk about all things personal injury law related. And up today, a story that made headlines here locally in Kansas City last year. We're going to talk about the tragic death of 3-year-old Titus Bass, who fell from a ninth floor window at the Independence Towers in Independence, Missouri. And we're going to talk about today the facts that surround that situation, the lawsuit that subsequently followed, the legal theories that were being pursued. We'll look at maybe some similar Missouri and Kansas cases and how they've unfolded over time, and then just the broader implications for landlords, tenants, and product safety. So this one kind of has an interesting twist because the parents of young Titus, who again did die from this fall, they are being criminally charged for their role in not supervising him and allowing him to encounter this open window that subsequently led to his fall and his death. And so, in the meantime, while they have these criminal charges pending against them, they filed a civil lawsuit against the apartment complex and I believe the window manufacturers, things like that. And so you kind of have these two different legal avenues happening. And again, it's really interesting because, on the one hand, you have the parents who legal authorities, law enforcement are pursuing criminal charges against, but you have the parents making a claim against others claiming negligence on their part. And so we'll kind of dive into that and look at the situation. But here's what brought it back into the news recently. Last week, the civil lawsuit was suddenly dismissed. Now, I don't know why the news doesn't indicate why the civil lawsuit, this is the civil lawsuit brought by the parents, why it was dismissed. But typically speaking, when the when the people that are bringing the claim dismiss the claim, there's a good chance that a settlement was reached and the case is closed. It could have very well been dismissed for other reasons, but certainly there's a good likelihood that it was resolved, which means somebody that they were suing paid them money, they accepted it as a settlement, and they've closed out the case. And again, with the pending criminal charges and whatever that might look like for them, I'm sure that they were motivated to move this case and work to get a settlement before any criminal proceedings finalize where they could potentially go off to prison. So again, kind of a very interesting, a very sad situation, but it's interesting in the legal realm of how all this is sort of interplaying together. When we look at the allegations and what we know about the Independence Towers, there was a transfer of ownership to and the management of those apartments to FTW Investments, 728 North Jennings, and Tango Property Management. And in this lawsuit, there were allegations of systemic neglect, mold, pest, broken windows, lack of AC, and continued ignored tenant complaint. Now, part of the allegations in all of this were that the window design was defective and that there were safety issues with the windows that were in place. There was the installation of Crystal Series 2300 windows that, again, according to the allegations, did not have fall prevention features, and that there was an alleged violation of the International Building Code as it is established in 2015. So again, all of this is in the lawsuit. They also alleged that there were a lack of child locks, guards, or restrictor devices that would have prevented this child from falling and being killed. So the particular morning that young Titus met his death, it was July 29th, so last summer. And according to everything we know, Titus opened this window in the extreme summer heat. He fell through a torn screen and he died later that day from his injuries. So, surrounding this incident, there were protests that were organized by residents and the KC Tenants Union. There were also enforcement attempts made by Fannie Mae against the property owners for failure to maintain habitable conditions. Now, in the lawsuit, the legal theories that were set forth by the parents of Titus involved the landlord's duty to maintain safe premises. They alleged failures with unsafe windows, lack of AC, forcing the tenants to have to open the windows, ignoring repair requests on the windows, and not providing a habitable environment. There was also a claim of product liability against the window manufacturer itself, which was Crystal Window and Door Systems. And those allegations revolved around a design defect in the windows, that it failed to incorporate child safety features, and there was a failure to warn the landlords and the consumers of the fall risk inherent with these defective windows, defectively designed windows. So the key legal doctrines at play in this lawsuit, of course, this was a claim made under the Missouri wrongful death statute. And again, any wrongful death claim in the civil arena, that is where a person is bringing a lawsuit for money damages for the death of someone, that is going to fall under the Missouri wrongful death statute. And there's a certain amount of people that are entitled to make that claim under Missouri law. And usually parents, siblings, grandparents, people like that are the ones that are able to make those claims. There's also, in this lawsuit, there are also allegations of building code compliance, which they allege the landlord failed to adhere to those, and they utilized the legal doctrine of negligence per se, which is essentially where the allegation is that a statute, an ordinance, a building code, something like that was violated. The person that was harmed was within the group of people that statute, ordinance, building code, whatever it may be, was designed to protect. And because of the failure on the part of the defendant to adhere to those codes, in this example, the person was injured or killed, as it was here. One other aspect of this lawsuit was the legal doctrine of foreseeability of child safety risk in high-rise housing, and allegations concerned with this particular scenario where you had a multi-floor apartment complex. The windows should have been such that there were protections in place to prevent people from falling out of them. When we look at some Missouri and Kansas cases for direction on how similar type situations have been handled in the past, one case, Miller versus River Hills Apartment, was a Missouri case from 1981, where the Court of Appeals held that the landlord was liable or responsible where there were unsafe conditions in the rental property, and that led to tenant injury. Another one from 1996, LAC versus Ward Parkway Shopping Center. that discussed the duty of care being heightened where harm was foreseeable. Missouri courts often emphasize that a violation of safety codes can establish negligence on the part of a defendant. In Kansas, there was Borders versus Roseberry, which in 1982, that case came out. That discussed how landlords can be held liable for known, unremedied hazards creating an unreasonable risk. And also Jones versus Hanson in 1987 out of Kansas, the Kansas Supreme Court there held that landlords have a duty to exercise reasonable care in maintaining rental premises, particularly where children are foreseeable users. And again, exactly what we have here. We have this young boy who was a foreseeable user around those windows. You have a high-rise apartment. This is the 9th floor. And so the allegations are the landlord should have been on notice, should have reasonably foreseen that a child could get hurt or worse if those windows were not safe. Now, on the product liability side, where the allegations were that something simply was not right about the window itself, it was defectively designed. In Missouri, the law recognizes strict liability for defective products. And strict liability simply means you're not having to prove all the elements of negligence in order to hold a defendant responsible. You just have to show that they put a product in the stream of business. It was either negligently manufactured or designed defectively, and as such, they're on the hook for something like this occurring. Kansas likewise applies strict liability where a product is sold in an unreasonably dangerous condition without adequate warning. And again, warnings can help offset a manufacturer's duty or responsibility in some situations, but it's not necessarily a get out of jail free card. Again, if they've designed something defectively, the fact that they warned against it doesn't necessarily mean that they're off. So when we look at a case like this and we kind of look at the broader implications, what are we taking away from all of this? Well, for landlords and property investors, if that's you, there's growing legal exposure for neglecting safety and affordable housing. A landlord cannot just ignore problems, safety issues, things like that are occurring in the properties they own. They must be diligent and they must stay on top of maintenance and repair. It's also the trend of investor ownership and cost cutting at the expense of tenant safety is definitely brought to the forefront when something like this happens. Again, you can't just buy a property, rent it out, and hope for the best. You have to be responsible and diligent in the maintenance and care of that property. Now, for tenants, the importance of tenant unions and watchdog organizations like KC Tenants obviously just kind of brings them to the forefront, because these are organizations that are working to make sure that housing, especially lower income, affordable housing, isn't being neglected, isn't exposing these residents to unreasonable harm, and that landlords are being held to the responsibility that they should have. There are legal tools that tenants can use. There's habitability statutes, there's building codes, and there is civil litigation just like this. Unfortunately, a lot of times the civil litigation, these lawsuits come after something bad has already happened. And everybody's goal should be working to prevent it from ever happening in the first place. Now, for manufacturers of products, they've got to keep in mind that they can be exposed to responsibility when something like this happens. There's expanding liability when products fail to account for child safety, especially in residential context. And over the years, there's been many different things. Something that comes top of mind for me is the furniture that was falling over and seriously injuring or killing children, and the subsequent development of straps that you can attach to the back of the furniture and attach it to the wall to ensure that a top heavy piece of furniture cannot fall over onto a child. And that's the same with, there's going to be warnings on maybe a TV, for example, about placing it on the top of an already higher piece of furniture, and the fact that if it falls off, it could seriously hurt a child. So that's just one more example of where manufacturers have to be thinking about, what are the risks involved when we're putting this product out into the stream of commerce for people to buy. Are we thinking through what are the potential hazards? And especially if they haven't, but all of a sudden children are getting hurt and it's becoming a more common occurrence, at that point, what is their responsibility to issue out a recall, issue out warnings, maybe something to address the problem, something like that. So again, this case highlights a few very important elements in our world today, especially when it comes to tenant-landlord relationships, systemic neglect, unsafe product design, and tragic preventable death. These are all highlighted by this situation. And, this could very well, this type of a case could very well set precedent in Missouri for landlord accountability and product safety. No question about it. Now, there will always be a question about what was the parent's responsibility here? Were they properly supervising their child when this occurred? And as I've discussed before, under Missouri law, there's a comparative fault analysis. So when someone is making a claim against somebody else, the fault of both parties can be analyzed by a jury. And so a jury might find the person that's getting sued or the company 100% responsible. They might find the person making the claim 100% responsible, or they may split it in some fashion between 0 and 100%. They might find it 50-50 fault. They can do whatever. And then depending on how the jury assesses fault, if they render a verdict of compensation to the person making the claim, the judge will reduce that verdict by any amount that the jury has assessed fault to the person making the claim. So very easy example, somebody gets a $100,000 verdict for some negligence claim. The jury finds that person 50% responsible for this accident. They find the defendant, the person or the company that's being sued, 50% responsible. The judge will reduce the $100,000 verdict to $50,000, taking off 50%. So that's how the law works in Missouri. And so that way, everybody can be fairly assessed in a situation with their own responsibility, because we hear about personal responsibility and the fact that people need to own up to what they've done. And this is a very fair way for a jury to take into account everybody's actions in a claim, and so that there's no unfair advantage one way or the other. And there's very likely, again, if this lawsuit had gone down the road, comparative fault would have absolutely been at play in this. Now, again, it's interesting because it was dismissed. And so, again, I'm going to assume there was probably a settlement, more than likely because of the nature of it. You have a child that was killed. There was a lot of heat on this apartment complex for its practices. Again, you had these parents who were probably motivated to move this along and get it resolved. More than likely, everybody came together, worked out some kind of a settlement to bring this to a close. And again, that's an assumption, but that's what I'm going with based on my experience. But, here's the other takeaway. If you're a tenant You should document all unsafe conditions. You should demand enforcement of codes, and you should seek legal help when necessary. We've represented many tenants on various unsafe conditions of rental property that have led to their injury or worse. And so we've definitely seen this in the past. We probably currently have clients that are dealing with these types of situations. And so again, if for some reason you find yourself hurt and you think it's the fault of your landlord and the failure of your landlord to properly maintain the premises, you're always welcome to reach out, give us a call. It's a free call. We're always happy to investigate and see how we can help. And so until the next episode, please be safe and be well.